I think it was a very good tenure. I look back at my 11 years very positively. I think I grew a lot personally as counsel, and I was able to impact the career development of a lot of younger counsel, some of whom have left the DPP's office before me and gone on to nicer jobs, sitting on the bench or gone on to their own practice. So it's been a good tenure, I think. I know I've worked very, very hard, and sometimes with some challenge, but I feel that I've been able to give of myself. I only know one way to work, which is to put everything in it, and I've done that. I've had some difficult cases, and I've had to do some difficult tasks. Like, for example, when I did the recusal application against a senior resident magistrate, Judith Pusey, in the current Spencer matter, that was a difficult thing to do, because to accuse any judge of any form of bias is something that puts you simply alone on an island. It's difficult. So I've had difficult experiences. It's been difficult at times to proceed with the Trafigura matter that I've done because of the personalities involved. Not that you are swayed by it, but it's difficult. However, in your job as a public prosecutor, you're not around to be popular. You're around to do the job and to follow the ethics that govern you. Because the DPP's office is a specialist practice area, that's criminal law. It gets criminal law and other matters associated with it, like international assistance. But I want to broaden my base. I want to do civil work as well. I want to do commercial litigation. Those are practice areas that don't come across my desk at all. So I could spend 11 years and another 11 years doing the same thing, or I could take a risk and start at the bottom again and do something different. I'm joining the law firm of Grant, Stewart, Phillips & Co. as a consultant. My primary support, or my primary requirement there, will be to support the litigation department, and that firm does quite a bit of commercial stroke civil litigation. But they've given me the liberty to develop private prosecution work in my practice area. I'm very focused on institutional fraud, institutional type crimes, larceny type and money laundering type offenses, which is really my forte. I consider myself and I'm recognized as an expert in anti-money laundering type support work. They're significant. The challenges are more, in my view, from the aspect of resources. We need a lot more to be able to do a far better job. Not only are there resources, but we have really institutional limitations. There are lots of cases that are literally crammed into a designated time slot with a minimum of courtrooms, available courtrooms, and an unwilling society for jurors and witnesses to come forward. So we prepare our cases, we do the best we can, but without jurors, we can't try matters that must go to jury. Without witnesses, we have limitations. And without physical space and without greater numbers, the rate at which we can dispose of matters is going to be impacted. Certainly, the administration changed in December going into January. And from the get-go, we know that there was a very critical look at some of the institutional challenges that we face. And we know that there's a lot of thinking going on as to how to improve the problems we have, how to improve security, how to encourage witnesses, how to improve the assisting jurors with the expenses they face while they try to do their civic duty, how to increase capacity. I know that the administration has been paying a very careful and consistent look at these issues. And I expect that if they're able to do some of the things that they've creatively identified they can do, then we should see some impact probably in another 2 to 3 years. I have seen a faster turnover of law creation perhaps in the last 4 to 5 years of my career. In my view, there's been a greater emphasis on passing and renewing laws that are going to help administration. I think there needs to be more attention paid to procedural law. how quickly can we get these cases through trial courts, and what are the ways we can shorten the actual proceedings. I know there are some proposed amendments to the Evidence Act, and I know that there's a lot of demand on the draftsmen, but I know that there's been attention being paid to law, modernizing it, renovating it, and bringing in new laws that will try and shorten the demands on the resources we have. She has her own style. She's very bold. She's very much engaged with the public. She wants to communicate to the public what her constitutional office requires her to do. So she's been behind the website, the launch of the website. She's been behind the launch of the protocol because of her philosophy that in public office you have public responsibility and the public pay her salary. She says that a lot. In the age of information, there's no other way to do it. You might as well talk to the people that pay you. So she's very strong. I've not seen her bow to influence. She makes her own decisions, takes a lot of criticism, but keeps on going. Everybody sees that smile. She's a good director, and I wish her well. Probably the sense that I'm serving primarily the people. I'll miss that. Sometimes when I prosecute, I think of the victim, and I think of the families, and I think about the little handcart man, or I think about the vendor who needs this system to work, even though he or she may not interface with it. And I get a sense of satisfaction from knowing I'm playing a part in ensuring that a citizen gets a good quality service. I'm going to miss interactions with the police because I've made myself very accessible to them. My interactions with my colleagues, some of whom have become my friends, that I will miss as well. But you know, like with everything, seasons change, things start, they end. And when they end, you don't clutch. You give it a loving goodbye and you move on.